I want to talk to you guys about appeals. And an appeal of a Prudential long-term disability denial is the first remedy or option if you've been denied. And Caesar, I want to go to you first. When someone calls you and they say, I've been denied by Prudential, they sent me something about an appeal. Talk about how important this appeal is in terms of doing it the right way.
So with Prudential, you often only have one bite of the apple, maybe two, if they give you a voluntary appeal.
Right.
But at least that first stage of appeal, that's considered mandatory under ERISA. So the real importance of that is that if you don't appeal during that time period, you basically then forfeit and abandon your right to continue pursuing those disability benefits. You can't then later say, well, I want to appeal now, or say, you know what, forget the appeal, I'm going to sue them now for my benefits. You're not going to be allowed to do that. The court will dismiss the case because you failed to exhaust administrative remedies. So number one, it's important that you don't allow that time period to lapse. Now you get into what the substance of this appeal is and what you need to provide and submit as part of the appeal that you're submitting to Prudential. And what's important here is not just ensuring that you're submitting sufficient supportive evidence that's going to hopefully have the decision overturned by Prudential, but also thinking in terms of what happens if Prudential, regardless of what I submit, regardless of how strong the evidence is that I put forth, what if they deny it again and I have to now sue them? Because in litigation, you're going to be limited to what was submitted during this appeal and what's within this administrative file that Prudential has and what you've built up through this appeal process. And if it hasn't been built up adequately, if you haven't submitted the appropriate evidence that will hopefully convince that federal court judge to overturn Prudential's horrible decision, then unfortunately you're not going to be able to recover those benefits.
Right, and a lot of people call us and they say, I got this denial letter. They basically told me just go ahead and write why I don't agree with their decision, but I didn't feel right about that. I found you on the internet and I see the stuff that you guys have been saying. So why should I have you help me do this as opposed to just putting it in on my own? And I tell people, this stage right now in this appeal is more important than who you're going to potentially hire down the road for a lawsuit. Because if you were to come to us and do your own appeal and then come to us for a lawsuit, we're married to whatever you have done already. I can't undo it. I can't call another single witness. I can't get any other information in at all whatsoever. And I tell them it is so restrictive, the law, that God forbid you got hit by a bus the day after Prudential made their final decision. We can't get that in. It's totally, there would be no doubt that you're disabled. Judge can't even consider that. That being said, the work you do on the appeal is the single most important thing. It has to be done to the absolute best ability possible. So Steve, when you're doing an appeal, just to give someone a quick summary, and we have tons of videos about appeals, but specifically with Prudential, what are the steps that you have to go through in order to submit a strong appeal?
I mean, I think first and foremost, the easiest is getting the claim file, so you see what they have, any of the internal reviews, the vocational reports. I think we've all seen situations in denial letters where they'll cite to a lot of what their reviewing doctor's opinions were, but when you see the full report, they even cherry pick those reports to what helps them. So being able to gather all that, but then also knowing from the get-go, what the definition of disability is. Are we talking their own occupation versus any occupation? Because that may open up the realms for vocational reviews. What the nature of the medical condition is, physically speaking, what type of testing we can do, functional capacity testing, work simulation exams to try to show physical restrictions, or if there's issues with cognition. So what additional information outside of just their medical records can we add to bolster it? Thinking about doing those things. And then I think a real important thing is with the client, really figuring out who the doctors to go to that they treat with are going to help. Because a lot of our clients have multiple doctors. And unfortunately, you find a lot of times the doctors don't really want to get involved. So sometimes it even becomes educating the doctors about the area of the law to the extent of, hey, listen, you're not going to get called to court. You're not going to get deposed. Your written records and opinions are all going to help. So really trying to work with that. So putting your best foot forward as soon as possible in the process. So as the information starts coming in, you can really build a cohesive argument. And that claim file, even though following COVID, they've gotten a lot quicker since now they're emailing or download leaks and things of that nature, they still have 30 days to get it to you. So if you're waiting 30 days to get the claim file before you're securing new medical records, testing things like that, you're just putting yourself behind the 8 ball. So I think it's a lot of it is the organization. And one thing I tell a lot, basically anyone that calls me with a denial is, and it's hard because it's a very personal process to them. So don't take it personally, right? It's very unique to you, but if you understand that this is the way insurance companies act, this is how they're going to operate, what they're going to do, it allows you then to build a really kind of logical game plan of how to, defeat the denial. And then echoing how Caesar said with the appeal, the mandatory appeal, Prudential gives you a voluntary, and some people think, well, I have a second one, so I'm safe. The mandatory appeal is the most important because in the voluntary appeal, Prudential doesn't have to send all your information to a new set of doctors.
They can do what they want.
You're now going back, generally speaking, to the same doctors and claims person who said you're not disabled and trying to prove you're disabled. Not to mention that voluntary appeal process, say we do new testing, functional testing, cognitive testing, then the argument becomes it's not time contemporaneous to the date of the denial. So some people, I think, do get a false sense with Prudential that, they've seen videos or heard that they get 2 levels of voluntary, but the mandatory is bar none the most important aspect of it.
I think on a positive, and you guys would probably agree, that if you present good evidence of Prudential, they're one of the companies who may reverse the denial, and I think we've had high success against them as opposed to some others where, this is a great appeal, you should win definitely, and then you get it back and you're like, well, that was nonsense. They sent it to their nurse and they're just ignoring all the information, just denying, just so you can sue them. I think Prudential internally actually does look at it, and you do have a good chance if you're a claimant, but if you don't put in an ironclad appeal, you're not going to win with Prudential because they will just shut it down, deny you, and then you're going to have a hard time. So.
And what folks also don't understand, Greg, is that, and this is the fallacy with submitting your own appeal, is that if you, like you said, you don't do a good job with that, that impacts the value of your case significantly, because the value of your case is based on what Prudential feels its exposure is. If you get, even though you may still have that option to file suit against them.
Right. Well, I tell people, if you've been denied, and a lot of people watch our videos for months or years, and then they call us if they ever need us. We always offer them a free consultation. We'll immediately review the denial letter. And while we can often tell them right from there, yeah, we want more information, or we think that you have a leg to stand on and we can move forward. But no fees or costs unless we win for them. So we always encourage them to call no matter where they live in the country. We'll be able to help them.